Am I audible? Participants? Am I visible and audible? Participants?
Yes, you are.
Yes.
Yes, you are.
Good afternoon. Welcome to the 32nd National Moot Court Competition 2023. Participants, please state your team codes. Petitioner side, please state your team code.
This is Team AL.
And respondent side, please state your team code.
This is Team U, ECU.
Thank you. Okay, now Team AL, how would you like to divide your allotted 45 minutes?
24 minutes for speaker 1 and 18 minutes for speaker 2.
And for rebuttal?
3 minutes.
And Team U, how would you like to divide your allotted 45 minutes?
Is there a multiplicity of the voice recordings? Because I can hear two voices.
Sorry. Is that okay now? Is everything all right? Can you hear me? Team U, am I audible?
Apologies. Yeah, we'll be dividing it with 27 minutes for the speaker 1 and 13 minutes for speaker 2, the rest being the rebuttals.
Okay, so from the petitioner side, speaker 1 will be speaking for 24 minutes and speaker 2 will be taking 18 minutes and 3 minutes for rebuttal. Is that right?
Yes.
And respondent side, Team U, speaker 1 will be taking 27 minutes and speaker 2 will be taking 13 minutes. And for rebuttal, you are planning to take 5 minutes. Is that so?
Absolutely.
Now, Team AL, would you like your intimation to be done verbally or through the chat box?
Verbally.
Okay. And Team U, would you like your intimation to be done verbally or through the chat box?
We would like it in the chat box, please.
Thank you, participants.
Candidates may please note, I am going to read the rules. The total allotted time for each team is 45 minutes. The court officer will be intimating the remaining time for each speaker at regular intervals. Any additional time taken by the first speaker will be reduced from the second speaker's time. The participants have to always keep the video on throughout the session. Now you may kindly wait for the judges to arrive.
Greetings of the day. Welcome to the final rounds of 32nd National Moot Court Competition 2023. Today, we are most delighted to welcome our esteemed panel of judges to this session. Firstly, we have Honorable Justice N. Nagaraj Sir. Sir has obtained his law degree from Bombay University and started practice in 1989 at Ernakulam. Currently, he is appointed as Permanent Judge of the High Court of Kerala with effect from 14 September 2020.
Secondly, we have Honorable Justice A. Badruddin Sir. Sir joined the Kerala Higher Judicial Services as District and Sessions Judge in 2009, and he is currently serving as Permanent Judge of the High Court of Kerala with effect from 25th January 2023.
And finally, we have Honorable Justice G. Girish Sir, and Sir has entered the Kerala Higher Judicial Service as Municipal Magistrate at Mavelikara on 3rd March 1997, and he got promoted as District and Sessions Judge in 2014, and currently sworn in as the Additional Judge of the High Court of Kerala from 25th October 2023.
We are grateful to all the judges for taking their valuable time out of their hectic schedule and joining us in the final sessions of the 32nd National Moot Court Competition 2023. We humbly welcome you all to this session. Now, with the judges' permission, shall I read out the rules of the competition?
Yes, of course.
Thank you, judges. Judges are kindly requested to note total allotted time for each team is 45 minutes. The court officer will be intimating the remaining time for each speaker at regular intervals. With your permission, shall we start the session?
I think if my brother judges, Justice Nagaraj sir and Justice Badruddin has arrived, then we can start.
Yes, we can go ahead now.
Thank you, judges. Judges may please note, this is session 1, chamber 1 with team AL and U. The participants may please note the session starts. The first speaker of the petitioner may begin. Petitioner side, you may begin now.
A very good afternoon. The council would now seek permission to collectively address the bench as your lordships. Much obliged, your lordship. The council is before the Honorable Supreme Court on behalf of petitioner, that is Postgram, in the matter of Rule 42 of IT Rules 2021, passed by the Ministry of Electronics and Information Technology. The council seeks permission to brief the facts of the case.
Yes, go ahead.
Much obliged, your lordship. Postgram is the most popular app among the inhabitants of Shantistan, which is a state in the Indian Union. This app is used by 1,14,80,000 people to create and share photos and videos. On 7th of July 2022, the newspaper Shantistan Times published a news with the title, Postgram is the champion of fake news, based on a study of 2 researchers who found that false news spreads significantly faster, deeper, and more broadly than the truth. The reason behind the same, according to them, was people sharing the inaccurate news items through Postgram. Following this news, Shantistan Times published another news stating that Postgram had not yet taken any action to comply with the IT Rules 2021. Postgram, aggrieved by the formulation of new laws, filed a petition before the Supreme Court of India under Article 32 of the Constitution, claiming their violation of fundamental rights. In response to the petition, Union of India has denied all the arguments, and the matter has been posted before the Honorable Supreme Court for final hearing. If your lordships are well versed with the facts of the case, then the council shall now proceed with the arguments.
Yes, go ahead.
Much obliged, your lordship. The petitioner have come up with 5 submissions, out of which 3 issues will be dealt by myself, and the rest 2 will be dealt by my co-counsel. Proceeding towards my first issue, my first submission is that the Ministry of Electronics and Information Technology does not have legislative competence to formulate Rule 42. This argument is based on 2 grounds. Firstly, the executive has performed an essential legislative function which is not permissible. It is humbly submitted that because a User Privacy Infringement Act is a fundamental legislative role, it cannot be delegated. The Rule 4.2 is a case of excessive delegation because Parliament has not provided any direction on traceability in this context. Furthermore, in the case of Vasantlal Maganbhai versus State of Bombay, this Honorable Supreme Court held that essential legislative function is the determination of the legislative policy and its formulation as a rule of conduct, which basically means that the executive cannot be given authority to formulate on lines of Rule 4.2. Only the procedural elements of the said rules can be delegated. Furthermore, under the IT Rules 2021, the intermediaries have been divided into two classes: social media intermediaries, referred to as SMIs, and significant social media intermediaries, referred to as SSMIs. The SSMIs have the task of observing due diligence and breaking of end-to-end encryption to identify the first originator of the message as the circumstances might require. This proposed action goes beyond Ministry's legal jurisdiction under the Act to create new categories of intermediaries or to give it the power to establish thresholds for these classifications. Secondly, Rule 4.2 of IT Rules 2021 fails to conform to the substantive provisions of the statute. Ministry has formulated IT Rules 2021 in exercise of the power conferred by subsection 1, clauses Z and ZG of subsection 2 of section 87 of IT Act 2000. However, the same was conferred to only regulate the intermediaries. A combined reading of section 79.2 read with section 89.2 ZG of IT Act makes it crystal clear that the power of ministry is limited to prescribing guidelines for observation. In this case, Rule 4.2 of IT Rules has imposed an additional requirement and have widened this ambit of requirements to be fulfilled by an intermediary. This obligation can only be adhered to after the messaging services technically modify their whole platform to either remove end-to-end encryption or add additional metadata to every message in a way that it undermines the security and privacy of the users. There is nothing in Section 79 of IT Act that suggests that the legislature intended to empower ministry to mandate changes to their technical architecture of services. Moreover, Your Lordships, the respondents have imposed criminal liability on the intermediaries for non-compliance to Rule 4.2. This does not find its validity in the Parent Act. Moreover, on the contrary, in the Parent Act, under Section 79, the intermediaries have been given a safe harbor provision as they provide a platform to people, and they have no role to play in case any objectionable content is posted by any person. In the light of aforesaid submissions, it is humbly submitted that the respondent has no legislative competence to formulate Rule 4.2 as it is beyond the scope of the Parent Act, and there is excessive delegation in terms that they have introduced new clauses and new classes on which they don't have any authority as it is not being mentioned in the Parent Statute. If your Lordships do not have any query regarding the first submission made, then the Council shall now proceed to the second submission.
Have you gone through the rulemaking power of the government of the state in the Information Technology Act, which is the section providing for the rulemaking power?
Certainly, Lordship, we have gone through the rulemaking power. Section 87 of the IT Act 2000 provides for the power.
Yes. Section 87, subsection OB provides that reasonable security practice and procedures and sensitive personal data or information. So is it not sufficient to make these rules?
Your Lordship, the rule power, the contention that we bring here for is that the government has rule-making power. However, the way in which they have exercised this power, they have basically compelled the intermediaries to break their end-to-end encryption. Such technical changes to bring technical changes in the whole modify such technical changes in the platform of the intermediaries, such compulsion that government does not have the power on.
Well, we'll come to them later. You come to the next point now.
Much obliged, Your Lordship. Proceeding forward, my second submission is that the Rule 4.2 of IT Rules 2021 is violative of Article 14. The premise of the same issue is based in twofold. Firstly, Rule 4.2 does not satisfy twin test of reasonable classification. And secondly, Rule 4.2 is arbitrary in nature as it suffers from vice of vagueness and ambiguity. It does not satisfy twin test of reasonable classification as laid down by Supreme Court in the case of West Bengal versus Anwar Ali Sarkar, 1952. The classification must have an intelligible differentia, and this differentia is construed as a difference that has the capability of being understood, and the classification should not be arbitrary, artificial, or evasive. Secondly, differentia must have a rational relation with the objective sought to be achieved. In the present case, in Rule 4.2, classification has been made between an SMI and an SSMI. The classification is based on the basis of number of registered users, and the same is decided by the Union of India. This classification lacks intelligible differentia as there is no set guiding formula or principle to calculate this threshold limit of users. It is purely based on whims and fancies of the government and can be changed without any due justification or consideration. Furthermore, these users are most likely to switch to SMIs following the implementation of the regulation, and the propagation of bogus news will still continue, which will nullify the whole premise of Rule 4.2. Secondly, there is no rational nexus that is established from this classification to the objective sought to be achieved. The Rule 4.2 will limit people's right to free expression and privacy. As a result, it is argued that there is no difference as identified. The government has not provided any objective sought to be achieved by this classification, neither has it given any justification for an SSMI to bear any extra burden on itself in comparison to an SMI, which is clearly discriminatory in nature. An SMI holds equal importance as an SSMI and is equally capable of spreading fake news. Therefore, the classification between the two is
Judges
unreasonable.
and participants, kindly note that, sorry for the inconvenience, as Justice A. Badruddin sir is facing some technical issue. Therefore, we have to pause the session for a few minutes. Is that okay?
All right.
Certainly.
Thank you, sir. Justice Badruddin sir. Am I audible? So shall we resume the session?
Yes, you can go. If Justice Badruddin has joined, then we will continue.
Sir, he has joined the session, but he's not responding. So, Justice Badruddin sir.
Wait, anyway, we have stopped. We will wait for 2 more minutes. Let him join.
Okay, sir. Badruddin sir, can you hear me? Justice Badruddin, sir. Hello. Badruddin, sir. Am I audible? Shall we resume the session, sir?
Oh, if we have time constraint, we will resume. Let him join.
No, sir, he has joined the session. Now he's trying to say something. Sir, can you please unmute? Sir, could you please unmute yourself?
Yes.
So shall we resume the session?
Yes, we'll go ahead now.
AL
will go
speaker
ahead.
1. You may resume.
Yes, yes.
You may resume your presentation.
Thank you so much. Your Lordship, should I go through my second submission again, or should I continue?
You proceed as you like. Yes.
Much obliged. Secondly, there is no rational nexus that is established from the classification to the objective sought to be achieved. The Rule 4.2 will only limits people's right to free expression and privacy. As a result, it is argued that there is no difference as identified. The government has not provided any objective sought to be achieved by this classification, neither has it given any justification for an SSMI to bear any extra burden on itself in comparison to an SMI, which is clearly discriminatory in nature. An SMI holds equal importance as an SSMI and is equally capable of spreading fake news. Therefore, the classification between the two is unreasonable and is violative of Article 14 of the Constitution. Secondly, if your lordships are with me, Rule 4.2 of IT Rules 2021 is arbitrary in nature as it is vague and ambiguous. In the case of Jai Singhani versus Union of India, the Honorable Supreme Court emphasized that the absence of arbitrary power is the first essential of rule of law, and discretion that is given to the executive authorities must be kept within very narrow parameters. The Rule 4.2 does not contain constitutionally adequate remedies of protection against arbitrary government action, since it allows tracing order to be granted either on judicial order or by any competent authority. By adding any competent authority, the mandate of judicial order has been removed and the power to determine this competent authority has been given to the state itself. So there are no checks and balances for the same. Moreover, the state is given complete discretion to impose such order against anybody. If I may seek for your permission for my researcher to share the screen.
Yes, go ahead. Yes.
Much obliged. If you may refer to the Moot proposition, the highlighted paragraph. The state is given complete discretion to impose such order against anybody, including members of press, investigative agencies, leaders of rival political parties, and military personnel. Such backdoor interference on the part of the state will have a tyrannical impact on the roots of the democracy and will disrupt the balance between state's power and fundamental rights granted to the citizens under the Constitution. Furthermore, in the case of Hiralal Ratanlal versus State of UP, 1973, the Honorable Supreme Court held that laws must be explicit and clear. A law is void if it is irrational, ambiguous, or fails to sufficiently inform a victim of the crime of what is prohibited. In the present case, second proviso to Rule 4.2 states that an order cannot be passed if there are other less intrusive means effective in identifying the originator of the information. In this regard, the government has not defined the meaning or scope of other less intrusive means. The phrase is vague in nature and is again left at the discretion of the government to interpret the same as per their whims and fancies. Therefore, it is humbly submitted that Rule 4.2 of IT Rule 2021 is arbitrary in nature, as it imposes unnecessary restrictions on postgram to curtail freedom, which has been done in the name of public interest and to safeguard sovereignty, integrity, and security of the nation. If your lordships do not have any query regarding the second submission made, then the council shall now proceed to the last and final submission.
See, the crux of the issue is that whether you could be compelled to disclose the origin of an information and encryption, end-to-end encryption. That is the crux of the issue. You say that as per the provision incorporated, there is some discrimination between SMI and SSMI, and that amounts to violation of your right to equality or something like that.
Certainly,
But
Lordship.
when it comes to the question of the national integrity or sovereignty of the nation, is not the government responsible, or government has the duty to incorporate appropriate provisions to safeguard the nation's interests? Can it be simply you can wash out the provision saying that there is some discrimination between SMI and SSMI, and hence it is violative of Article 14 and it's liable to be eschewed as such?
Your Lordship, to address your concern, the primary concern is that in order to identify the first originator, intermediaries such as Postgram would have to break end-to-end encryption for all the public at the larger level, and for every user who has been using this platform. The manner in which the government has exercised its power, the manner in which they have brought 4.2 in enactment, that way it will directly encroach upon the fundamental rights of all the citizens, not just one user. The intermediaries are very well equipped and ready to follow all the rules. However, in context of Rule 4.2 only, they'd have to break end-to-end encryption, and at large, everybody's privacy who has been using this intermediary as platform would be compromised. That would include media personnel, rival political party leaders, military personnel, media press, and even lawyers and clients, as it is referred to in the Moot proposition.
See, it seems that your apprehension is about arbitrary act from the part of the government. What if the government, the orders under Rule 4.2 can be passed by government as well as by judicial authorities? Is it so? So, are you saying that if that provision is restricted to judicial orders from judicial authorities alone, then your grievance is redressed?
Your Lordship, in context of judicial order, they have removed the mandate of judicial order as they have added any competent authority. We are contending over here is that the arbitrary power and the scope that it leaves for arbitrary government action, which will most probably lead to abuse of power by the government. Hence, it is arbitrary in nature.
See, are you saying that as the provision stands now, there is judicial authority, there is no provision incorporated therein for the judicial authority to pass orders under Rule 4.2?
Certainly not, Your Lordship. We are also contending there are plus factors attached to it. The mandate of judicial order has been removed by the government as per their discretion, and there are other plus factors that are attached to it that makes the law arbitrary in nature, as it is also void because it contains irrational and ambiguous phrases in it.
That's why I'm asking. That's why I'm asking whether that is that particular clause regarding the orders being passed by competent authority, that is removed, and it is exclusively reserved for orders from the part of the judiciary. Then will it not redress your grievance in this matter?
Your Lordship, in case of that also, there are other plus factors that are attached to it. The rule in itself will be reflective of arbitrariness, and it will be violative of fundamental rights also. It does not only violate Article 14, it also violates Article 19 and 21 of the Constitution for all the people who have been using this platform.
Are you saying that when there is a question of sovereignty and integrity of the country, then your fundamental right is more important than that?
Certainly not, Your Lordship. We are saying we are contending that there is a need to balance the both. In case of Rule 4.2, we are very well ready to, in case the government brings in new rule, and the implementation of the same will be taken by all the intermediaries. However, in this particular rule, we have a problem of violation of fundamental rights of not only citizens but also the traders. In case there is any question of sovereignty or security of the nation, we are very well equipped and ready to take the content down if it has been posted by any user, and we have other means of taking such content down or curbing the spread of fake news that are there in the place.
Dear candidate, am I audible to you?
Yes, certainly.
Audible. Yes. You see, you are much aggrieved in the matter of Rule 4.2, which permits the identity of the messages to be disclosed only when the same relates to certain matters provided in the first proviso. That includes for the purpose of prevention, detention, investigation, prosecution, and punishment of an offense related to the sovereignty and integrity of India, the security of the state, etc. You are well aware of the fact that fundamental principles as such are available to be a citizen, but that is subject to reasonable restrictions imposed and recognized by the constitutional courts as well. Then see that false messages being circulated by persons, then what will happen? Anybody can make any type of false messages and circulate throughout India and outside. Eventually, what will happen is the integrity of the country, the security of the country, and the peaceful living of the people would be adversely affected. In such contingencies, whether we can say that the government has no power at all and the freedom as such shall be allowed for circulating any false messages, which would particularly affect, even in my view, Section 44.2 would apply only to those cases. So there must be some control by the government. Otherwise, the system, the country, everything will be in trouble. That is why this rule came. But obviously, I do agree with the fact that this is not a legislation. It is only a rule framed by the government authorities and not by legislation. Then what you say that how, when a question comes, whether the supremacy of the country with as far as security issue is concerned, when competes with the individual freedom as guaranteed under Section 14, 19, and 21, which will provide, we will must have given preference to the security of the nation, not otherwise. Then how will you say that this legislation otherwise would violate fundamental rights?
Certainly, Your Lordship, I understand your concern.
Speaker,
However,
one may please note you have 5 minutes remaining.
I understand your concern. However, to address your query, in order to identify the first originator of information, the intermediaries would have to break end-to-end encryption, and they would have to go through a chain of encrypted messages in order to identify the first originator and
Yes,
give
yes.
their information to the government.
Yes.
However, the discretion that is given to the government, and as to in the context of the provisos, there are no checks and balances maintained for the same. We have been seeing recent cases where government has misused the power, and there is a scope of abuse of power by the government. There have been so many cases in which they have done so. So, in order to ensure that there is no scope of abuse of power, they have not left there are no checks and balances for the same in the provisos or the rule. In case as far as security of the nation is concerned, the intermediaries are very well ready to willingly comply to all the provisions and rules that they have implemented. We are very well equipped by taking such objectionable content down, or blocking such accounts, and there are other means that will secure the nation's integrity, and that will also secure the privacy of the citizens of India.
Then you may please go through the section 43 of the IT Act. What section 43 says? 43 of the IT Act says that deals with penalties, compensation, and adjudication, etc. Then 44. Penalty for failure to furnish information, return, etc. If any person who is required under this Act or any rules or regulations made thereunder to furnish, that means the first category covered by the Act, second category covered by the rules, third category covered by the regulations. That means, in view of the mandate of the Act, rule-making authorities have given a delegated legislative power to make rules and regulations. If so, ignoring the fact that the present rules, even though it is not the outcome of a legislation, by imparting the power of delegated legislation, if the rules, if applied, nobody could say that the same is against the mandate of IT Act, because IT Act section 44 specifically provides punishment for not only violation of the Act, but for rules and regulations thereafter. Then how will you say that because of want of legislation, this rule is otherwise not succeed in the test of constitutionality?
Your Lordship, to address your concern, the rule far falls beyond the scope of Parent Act, as they have also imposed criminal liability on the intermediaries in case they fail to provide the information of the first originator.
Speaker one may please note you have 1 minute remaining.
Your Lordship,
May please give 5 minutes more, moderator. Please give 3 minutes more. Yes.
Okay.
Yes.
Much obliged.
Yes.
So in the present case, Rule 4.2 has also imposed criminal liability on the intermediaries in case they fail to provide first.
You please one intervention. You please read 4.2 read with the section 44 of the IT Act. There also there is penalty. That is also in non-form prosecution. And how will you say that the prosecution imposed as per the rules is as against the statute of the Act itself provides? Then it is a supplementing rule. You continue, yes. 44 and 4.2 read together. 44 of the Act and 4.2 of the rules.
Your Lordship, in case of section 44, it
Yes.
provides for a penalty.
Yes.
And that to a person who does not comply to such rules or regulations.
Yes.
However, in Rule 4.2, criminal liability has been imposed on the intermediaries in case they fail to provide first originator of the information.
Yes.
This falls beyond the scope of the Parent Act, as if I may refer you to the section 79 of the Act.
Yes.
And my researcher will share the screen.
Yes.
Under section 79 of the Parent Act, a safe harbor provision has been given to the intermediaries in case they follow due diligence that we have been following. So no liability on intermediary can be imposed because intermediaries only provide a platform to people. They are not responsible. They're not responsible for any content that is being posted by the people. In case they are following any due diligence and they are ready to take out the content or take off the content of the platform, they cannot be imposed. They cannot be held to be criminally liable for the same.
Yes, what I intended is whether you will refer section 79. You correctly referred. Yes. Then there may be some repugnancy. We can consider. Yes.
Let's go ahead now.
Much obliged, Your Lordship. Proceeding forward, my third submission is that the rule is violative of Article 21 of the Constitution. In the case of K.S. Puttaswamy versus Union of India, 2017, the 9-judge bench of Honorable Supreme Court held that the right to privacy is a constitutionally protected right in India, and they laid down 3 requirements that must be satisfied to justify an intrusion into the fundamental right of privacy. Firstly, legality. Secondly, necessity. And thirdly, proportionality. However, in the present case, none of these are satisfied. Firstly, as it suffers from vice of illegality, the executive, through a subordinate law, may only formulate rules that are consistent with the Parent Act. Nothing in Section 79 of the IT Act 2000 shows that the legislature wanted to give ministry the authority to compel service providers alterations to their technical design or to jeopardize user privacy. Secondly, having autonomy and control over our lives, which are essential elements of a democracy, would be impossible if ongoing mass surveillance is continued. A democratic society can never have the goal of monitoring people's lives in this way. Hence, it violates the principle of necessity. And lastly, in the case of Kerala State Beverages versus PP Suresh, a minimization principle was laid down, and the Honorable Supreme Court held that to be proportional, infringement of fundamental rights should be through least restrictive alternatives. However, in the present case, breaking the end-to-end encryption will put the privacy of millions of users at risk. And the result will be the public revelation of people's personal information, which will lead to mass surveillance. When mass surveillance clearly infringes on people's privacy, the minimization
Speaker
principle,
1 may please note you have 1 minute remaining.
the minimization principle will be broken. The rule gives government the authority to intercept messages in the event of a crisis or in the interest of public safety without specifically defining the guidelines that must be followed. Hence, it is violative of Article 21 of the Constitution.
Yes,
If you lord-
one more doubt. Promoter, please give 1 minute. This is my question. You see, will you agree with me? Section 79 is amended by deleting the protection given in favor of the intermediaries, and the Parliament itself is legislating a law similar to that 4.2, and with intent to protect the sovereignty and integrity of India, particularly with a mention to security, to keep the security of the state intact. Do you agree that if such a legislation comes, amending 79, which will protect the intermediaries, will you agree that if a harmonious construction be given in between the fundamental rights and the security of India, can such a legislation would succeed?
Your Lordship, if such legislation makes sure and ensures that there are
Yes.
checks and balances to ensure that there is no abuse of power or there is no scope of abuse of power that is left within the hands of the government, in my opinion, that such legislation would work.
Definitely. Okay.
If your lordships do not have any queries regarding regarding the submissions made, I will now call upon my co-counsel for her submissions.
Yes, go ahead.
Much obliged, your lordship. It was an honor arguing before the honorable court.
Speaker 2 may please note you have 17 minutes remaining. You may begin.
Good afternoon, your lordships. If the lordships don't have any further queries regarding the issues presented before by my co-counsel, then I would seek the permission of the lordship to proceed with my issue.
Yes, you can go ahead.
Much obliged, your lordship. The first issue I'll be dealing with is the Rule 4 Clause 2 of IT Rules 2021 is violative of Article 19(1) Clause A. Freedom of speech and expression is indispensable in a democracy. Article 19(1) Clause A guarantees all citizens right to freedom of speech and expression. This right includes freedom to express views through any medium. However, Article 19 Clause 2 states that Article 19(1) Clause A is subject to reasonable restrictions, and this restriction of speech must have a proximate connection with the specific 8 heads set out in Article 19 Clause 2. However, the impugned Rule 4 Clause 2 fails to qualify the test of reasonable restriction provided under Article 19(2) on the basis of 2 grounds. Firstly, Rule 4 Clause 2 of IT Rule 2021 is overbreadth and vague, leading to a disappropriate chilling effect on speech. And secondly, the restrictions are not proportional to the objective it wants to achieve. If I have the lordships with me, I'll be proceeding towards my first sub-issue. it is humbly submitted that Rule 4 Clause 2 violates Article 19(1) Clause A of the Constitution of India, as it will have a chilling effect on freedom of speech and expression. The chilling effect is stifling the right to free speech through excessively broad laws, as it is an unwelcome restriction on one's right to free expression out of the concern for surveillance. When determining whether a law is constitutional, the court must take into account for both the immediate and the inevitable effects of the restrictions imposed. To explain my issue, I'll be dealing with this issue on two grounds. Firstly, the chilling effect is caused by the impugned rule being overbreadth in nature. And secondly, the impugned rules suffer from the vice of vagueness and arbitrariness. Proceeding towards my first ground, the impugned rule is overbreadth. A restriction on speech is said to be overbroad when it restricts both the speech that government can legally restrict, but also goes on to restrict other speech that is constitutionally protected. To enable the identity of the first originator of information in India, SSMIs would have to build a mechanism that would permit tracing of every communication sent in India on its messaging services, including those who are using these services lawfully, as there is no other way to predict which message will be subject of such order, thereby seeking first originator of all the users, leading to the violation of their right to anonymity, which is included in the right to privacy, as laid out in the case of Central Public Information versus Subhash Chandra Agarwal. This is also contrary to the Honorable Supreme Court's judgment, Gobind versus State of MP, that surveillance must be only limited to those people whose conduct shows a determination to lead a life of crime. If I have the permission of the Lordship, may I ask my researcher to present the screen?
Yes.
Yes.
Much obliged, the Lordship. If your Lordship may refer to the highlighted paragraph, it is therefore humbly submitted that breaking the end-to-end encryption would create a fear in the minds of journalists, civil society organizations, members of ethnic or religious groups, activists, academicians, and artists, as they would not be freely able to express themselves on such platforms. Therefore, in the present case, breaking end-to-end encryption of all the users to find the first originator is overbroad and imprecise, as it intimidates the speaker, such as journalists, publishers, to err on the side of caution and refrain from speaking altogether, rather than taking a chance that their communication would be seen as a crime. Therefore, the said rule is said to be overbreadth in nature. Proceeding towards my next ground, that this rule suffer from the vice of vagueness and arbitrariness. In the present case, the second proviso to the Rule 4 Clause 2 states that the order cannot be passed if there are other less intrusive means effective in identifying the first originator information. In this regard, but the government has not defined the meaning of the other less intrusive mean. Therefore, the phrase is very vague, and it is left on the discretion of the government to interpret the same as per their whims and fancies. Also, given under the first proviso that if in words like prevention, detection, investigation, prosecution, or punishment is very overbroad in nature, as they can be widely be misused by the officers that hold power, as it is left on their discrepancy, and this can be used by them in misuse of their power, as they can curb free dialogue and dissent. Therefore, it is humbly submitted that Rule 4 Clause 2 of IT Rules 2021 is arbitrary and imposes unnecessary restrictions on postgram to curtail freedom. Therefore, the said rules are said to be causing a chilling effect, as the impugned rules are overbreadth and vague, resulting in violation of Article 19(1) Clause A. If I have the permission of the Lordship, may I proceed towards my next sub-issue?
One question. Dear participant, please listen for a moment.
Certainly.
On reading 4.2, it is emphatically clear that the same is a special provision made for the purpose of getting the source of the messages, which would affect the integrity and sovereignty of the country. See, that is also subject to two riders. The first rider is it may be enforced through an order of court or by the order of a competent authority appointed under Section 69 of the Act. 69 deals with the powers to issue directions for interpretation or monitoring or description of any information through any computer resource. So only by the order of the court or by the order of a competent authority in matters dealing with particular reference, sovereignty and integrity of India. That is a classification which we will have to read as a reasonable classification. And therein also another clause is there, provided. Please read second proviso. Provided further that no order shall be passed in cases where other less intrusive means are effective in identifying the originator of the information. So only when the second proviso is not operative, government, by fixing two conditions, which are one by the order of the court or by the order of a competent authority, can insist for disclosing and getting the source of the message, which could in fact affect the sovereignty of the country. In such cases, how can you say that this rule is violative of Article 14, 19, 21, etc.?
Certainly, Your Lordship.
Yes.
I agree with your contentions.
Yes.
But however, the restriction they are imposing is not reasonable in nature. We agree that to protect the sovereignty integrity of the country, we need to impose some type of checks on the platforms to see if that fake news is not being spread on these platforms. But to enable such check, we have to break the end-to-end encryption of all the users, and therefore will be violating their right to privacy and freedom of speech and expression. We are okay with imposing other less intrusive means also, as given in second proviso, but the phrase other less intrusive means has not been described by the government. Therefore, it's on the whims and fancies of the government that they can define it however they want to misuse this power. We, as an intermediary, want to comply with Rule 4, Clause 2, but not on the cost of violating the fundamental rights of the citizen.
That's all. Then you may please listen. Please may listen. If there is legislative vacuum, the courts here are in fact explaining the terms. If the statute doesn't contain a clear definition what is intended, normally the court will go on to interpret it. Ultimately, it will be held that the contingency dealt under the second proviso should be on these parameters, and fixing a parameters balancing the privacy of an individual intact with the freedom of speech and expression, and also balancing the right of the government or the administrator of the country to deal with and to protect the integrity. Something should be done. You see, for example, we are governed by certain principles. Now in CRPC, there are provisions thereby a person is bound to give his voice sample for the purpose of comparing whether his voice is used for commission of crime. That is legally prohibited. Similar is the position insofar as collection of examination of blood for the purpose of DNA profile for proving criminal cases of various nature, particularly to rebut the conclusive proof as to paternity of a child. So we can't lay down a rule or a proposition that whenever there are certain types of infringement on the fundamental rights for achieving a big goal better than that of the private right, and the aim is to protect the interest of the country, though a balance should have been there, and we can never say that government is powerless to go for a legislation inclusive of 1 under 4.2, though in this particular case, this is not a legislative rules. Okay. Yes.
Your Lordship, I agree that for the bigger picture, that to protect the sovereignty and integrity of India, government has to come up with such rules. But by incorporating such rules, it is hampering the fundamental rights of the citizens of the country. It is not only the citizens, but also the traders of the country. It is infringing upon their right to trade. As it has also been clearly laid out in Section 79, the safe harbor provision, that intermediaries will do not have to comply with such orders if it falls under their due diligence. Then also the intermediaries are being forced to break their end-to-end encryption, alter their fundamental mechanism on how their platform is working, because we as an intermediary are promising all our users that we'll be providing them safe platform that their information would be private, no such information will be leaked outside, and they can freely express themselves on such platform. But through imposition of such rule 4 clause 2, we'll be altering our fundamental principles, and therefore it will also lead into a reduction in our business, because users would not be willing to now use such platforms where we are not giving a strong private platform to these individuals where they can freely express themselves. Therefore, we are contending that we would be willing to help the government to curb the spread of fake news, and we are already doing that. We are blocking their content. We are removing the content that is spreading the fake news. We are blocking those users that are trying to spread fake news. We are broadcasting on our intermediaries that the news that people are referring to right now is fake. But breaking into encryption to cost of stop the spread of fake news is not reasonable.
You see,
case.
Yes.
Okay, sir, you may proceed.
Yes. You continue.
Yes.
I shall.
Okay.
Yes.
Yes, Miss Participant, take a case where a message has been circulated through your social media platform, a highly volatile message, inciting communal feelings, and which may result in vast clashes between groups, leading to arson and many insurgents. Say such a message is being circulated through your social media platform, and that too, that message originated from somebody operating outside the country. See, at the initial stage of investigation, it is highly necessary to trace out the origin at the earliest, especially in cases like this. The investigating agency will have to resort to the help of Interpol and other agencies like that. It has to be done at the earliest. So, unless it is done at the earliest, the investigating agency may not be able to book the culprits in certain cases. So, suppose in such a case, if ultimately it is found that it was a fake message and actually it doesn't happen so, still are you not able to suffer or at least dedicate or sacrifice your freedom of speech or expression, at least to a certain extent, for the sake of booking the culprits?
Your Lordship, we are willing to sacrifice our freedom of speech and expression to a certain extent. But as I said, by imposing Rule 4 Clause 2, we are being compelled to break the end-to-end encryption of all the users. Therefore, the users would be not able to freely express themselves on such platforms at all, as I laid out at the concept of chilling effect. If I may explain it to you through an analogy, if I go to a shop and there is a CCTV camera if I know there's a CCTV camera being monitored on us, then I as an individual will not be willing to take a risk and will not be behaving normally as I would. So it will cause a constant fear on the minds that I'm being monitored. So I need to speak. I cannot speak freely. I'm with full freedom, and I'll be restricting my speech to a certain extent, which the government does not interpret it differently on their whims and fancies.
Counsel, you are fundamentally wrong for two factors. One is that end-to-end encryption is not a holy cow. It is something which you have assured to your clients. You don't have, there is, at least so far, there is no fundamental right for end-to-end encryption. So far, it is not there. Now, take the case, if this is your business interest. Suppose this interest, a courier company comes out and say, we will assure end-to-end encryption. Give us any luggage. We will not touch. We will not open. We will keep your secrecy. We will not disclose who gave this baggage, to whom we have delivered this. What will be the impact? All smuggling, hashish, gold, arms, everything can be transported. Because you don't have such a right. You don't have a right to say that end-to-end encryption is our fundamental right. That should be subordinate to the national interest. That should be subservient to the national integrity. That should respect the national security. And why do you think that in every case of fake news, the government will come and ask you to disclose the first originator? It is not in every fake news that the government will interfere. Only where this news has created or is likely to create issues of national security, social harmony. Only in those cases, government will come, isn't it?
Certainly,
And
Your
on
Lordship.
and on what basis you are telling that there is mass surveillance, chilling effect? These are all your projections.
Certainly, Your Lordship. I agree.
If a customer sends an ordinary message, why should he worry about disclosing that first originator?
Certainly, Your
Speaker
Lordship.
to me, please note you have 5 minutes remaining.
Yes, go ahead.
Certainly, Your Lordship. I agree with the contentions. I'm not contending that end-to-end encryption is a fundamental right. But by providing end-to-end encryption, our fundamental rights are being protected, because end-to-end encryption ensures that our fundamental right to speech and our right to privacy is being exercised properly. And to your second contention, that if that courier example you give, that people may misuse this advantage, the advantage they are being given, on that I like to contend that we agree that fake news needs to be spread, and it needs to be stopped for the security and integrity of the country. And we are already working on that path, and we are trying to curb the spread of fake news. But if we have to break the end-to-end encryptions of all the users to find out the first originator of information on our platform, then the users would likely to switch to the SMI, who is providing them with a good, strong end-to-end encryption platform. Therefore, they would not have to comply with the Rule 4 Clause 2. And therefore, the objective that the government wants to achieve would not be achieved, because the users would be switching from SSMIs to SMI, and they would not have to comply with the Rule 4 Clause 2.
Dear participants, please.
Yes.
The first part of the question I intended to ask was asked by our brothers. Then I am confining the second part alone. You please read proviso 3 to section 4 to
Certainly, Your Lordship.
Provides that in complying with an order of identification of the first originator, no significant proviso 4 provided also that where the first originator of any information on the computer resource of an intermediary is located outside the territory of India, the first originator of that information within the territory of India shall be deemed to be the first originator of the information for the purpose of this class. This proviso is very cleverly drafted, because there may be instances whereby somebody who is outside the states, and normally without a specific sanction or by procedure, following the procedures prescribed therein, we may not be able to prosecute that perpetrator of the crime. Then it is easy for the terrorists and other anti-social groups to go outside, stay there permanently, then make some messages of this nature which would affect the integrity of the country. Then intent the same will be circulated to a person in India, and he himself is circulating the same to your social media to the various persons. Then such a situation should have been dealt by a legislation. I do agree with that. This is only rules, not by legislation. This is not the outcome of legislation. Anyhow, how can you curtail the powers of the government to address the issue as regards the integrity of the country by saying that such rule violates so and so, so and so? We are all well aware right from the very beginning of the studying law that reasonable restrictions is the rider always in the middle when we are exercising the fundamental rights. It's not absolute always, subject to reasonable restrictions. You may be right in saying that these rules, in fact, issued by the government without a legislation, may have certain legislative vacuum, some vacuums to be fulfilled. If the government himself or the legislature is not addressing it, definitely court will intervene. Then there may be interference. which may go to ensure that fundamental rights should be protected subject to the reasonable restrictions, and also ensuring the power of the government to inquire into. Then how can we outrightly say that such a power is always against fundamental right and it infringes the right of the privacy, etc.? In fact, on my reading, section Rule 4.2 is dealing with only regarding certain messages when the same would affect integrity and sovereignty. All others fully excluded.
Certainly, Your Lordship. I agree
Yes.
with your contention.
Yes.
If you
Yes.
may note that under the new rule, a grievance officer has been appointed. If something is
Yes.
found objectionable, they can report
Yes.
to the officer and it will be resolved or taken down
Yes.
within 24 hours.
Yes.
Therefore,
Yes.
rule by putting a burden on the intermediary to comply with Rule 4 Clause 2 would be an extra burden on the intermediary, as they would have to break end-to-end encryption of all the users. And
You
then
may understand, please, you may understand these rules in this way. The rule is intended to impose a restriction on the social media platform to ensure that they may not support publication, that means reading of the content which is not good for the nation, and you being the social media controller should arrest such messages by yourselves unless you are not able to disclose it when the government asked for. So the such restriction we can't say in a simple way that it is against fundamental right, etc. Such restrictions are necessary. We as a sovereign country should have to survive throughout. If we are allowing relaxation in these matters, what will be the effect? Our country will be ruled by terrorists, and also our country will be in a state of lawlessness because of the fake news and fake messages. You may be aware, during the period of Hitler, there is a way publishing a fake news repeatedly. Then repeatedly when published, it become on the ears of the people and they believed it as reality. That is the way in which fascism was imposed by Hitler in Germany. Then such a situation we must avoid. We are a country having most respect to democracy, but that shall be giving first priority to the interest of the country, then the interest of the citizens. Okay.
certainly, Your Lordship.
Yes.
I agree.
Yes.
I totally agree with your contentions.
Yes.
Your Lordship, but intermediaries are already being regulated by other rules, and there that are in place. And the spread of these
Speaker
news.
2 may please note you have 1 minute remaining.
Your Lordship, may I seek an extension?
Yes. Yes.
Certain. Much obliged, Your Lordship. And the spread, and as I said, if we have to, as an SSMI, I have to break the end-to-end encryption on my platforms, then the intermediaries would have to switch to SMI, making that SMI. Therefore, the SMIs would not have to comply with the burden of complying with Rule 4 Clause 2. Therefore, on such platforms, fake news will still be spread out on such platforms, and therefore the objective that the government wants to achieve, that the fake news should be stopped, would not be achieved. At the end, the government wants to achieve the spread of fake news, but to achieve such goal, the rule that they are imposing is violating our fundamental right. And even after violating a fundamental right, the objective is not being achieved because people are shifting from SSMIs to SMI, and it's making the SSMI and SMI. Therefore, they do not have the burden to comply with Rule 4 Clause 2, and the fake news would still be spread on such platforms.
Yeah, we have many persons prior to independence and after independence committed murder. Somebody were given severe punishment. Somebody in jail. Somebody is undergoing imprisonment. Still, we have crimes. So, punishment imposed for committing a crime is governed by 4 more theories. The first and foremost is the retributory theory. That means to make the society aware that if you come with this, your fate will be this. So that fear, retribution will go in the form of a message to the mind of the citizen to refrain from doing it. That is what is intended by this legislation also. This legislation, government or the system as such is not at all expecting that because of this rule, there may not be any violation, any spreading of messages. But we will have to have a check on it. Then with a view to retribute. Those who are indulging will be punished.
Certainly,
Yes.
there is,
Yes.
as I stated already, there is already a check, because if any person on this platform finds that any communication is subject to objectionable content, they can report to a grievance redressal officer and the
Definitely.
officer will take down that within 24 hours. So there
Yes.
are already other rules in place to stop the spread of fake news. And
Yes.
we as intermediaries are also working on stopping by blocking that person, removing the content from a platform, by publishing on our intermediaries that this news that is being spread is fake. But to
Yes.
comply with Rule 4 Clause 2 and breaking end-to-end encryption fully on the platforms, and then removing their right to violating their right to privacy and freedom of speech and expression is not reasonable to the objective that the government wants to achieve.
Yes.
Speaker to me, please note your allotted time is over.
Your Lordships, if I may seek an extension of 5 minutes to complete the last issue and my prayer.
Yes, you may complete within 3 minutes because we are running out of time.
Much
Try
obliged.
to be in 3 minutes. Yes.
Much obliged, Your Lordship. The last issue I'll be dealing with is that the Rule 4 Clause 2 does not impose a reasonable restriction under Article 19 Clause 6 of the Constitution. It is submitted that Article 19(1) Clause G guarantees right to practice any profession or to carry on any occupation, trade or business. This right can be reasonably restricted in the interest of general public given under Article 19 Clause 6 of the Constitution. However,
Yes.
the IT Rule 2021 is not in the interest of general public on the following grounds. Firstly, trust and privacy concerns. End-to-end encryption provides a secure and private communication channel between users, and breaking end-to-end encryption would erode trust in these platforms, leading to users less likely to use the platform for sensitive or commercially confidential communication, and this could result in the reduction in their business and trade activity. Secondly, it would lead to competition. Intermediaries that break end-to-end encryption may find themselves at a disadvantage compared to those that maintain strong privacy and security protection for their users. This will also result in the reduction on the loss of market share and decrease their overall trade. And lastly, it will impact innovation. Encryption technologies plays an important role in enabling new ideas and innovative business models, particularly in digital economy. Breaking encryption would stifle their innovation and restrict the growth and in the digital economy of the country. This, therefore, by imposing Rule 4 Clause 2 of IT Rule, it will infringe upon their right to free trade and occupation, and the restriction imposed would not fall under the various exceptions given under Article 19 Clause 6. If the Lordships have no further queries regarding the issues presented, then I ask the permission from the Lordship to proceed towards the prayer.
Yes.
Much obliged, Your Lordship. Wherefore, in the lights of the facts presented, issues raised, arguments advanced, and the authorities cited, the Council, on behalf of the petitioner, humbly prays before the Honorable Court to adjudge and declare that, firstly, the Ministry of Electronics and Information Technology does not have a legislative competency to formulate IT Rules 2021. Secondly, the Rule 4 Clause 2 of IT Rules 2021 is violative of Article 14. Thirdly, the Rule 4 Clause 2 of IT Rules 2021 is violative of Article 19(1) Clause A. Fourthly, the Rule 4 Clause 2 of IT Rules 2021 is violative of Article 19(1) Clause G. And lastly, the Rule 4 Clause 2 of IT Rules 2021 is violative of Article 21. And or pass any other order, direction, or relief it may deem fit in the interest of justice, equity, fairness, and good conscience. For this act of kindness of your Lordship, the petitioner shall duty-bound forever pray. Thank you, Your Lordships. It was an honor arguing before the court.
You may please always remember that to do trade and business is a right guaranteed by the Constitution of India. If a person under that freedom sell narcotic substances, liquor, if he is able to sell some substance which can create explosion, these are all governed by special statutes so that those substances are not at all subject matters of trade or business. So every trader or business should know that there are restrictions imposed by law in conformity with the fundamental rights, and everybody is bound to obey it. And the trade and business shall be always subject to exceptions provided in the statute or not otherwise. Similar is the position insofar as trade and business dealt under the social media platforms for sending messages, whatever it may be. There are also restrictions should be imposed so that the government is having the power to intervene when the integrity and security of the country is affected. Yes.
Sir.
Yes. Okay.
With the judge's kind permission, shall we start the respondent side arguments?
Agreed, sir. Yes. Agreed, sir.
Go ahead. Next team can start replying.
Yes.
The
Yes.
first speaker of the respondents may begin.
Yes.
Greetings to the bench. The counsel for the respondent seeks the court's permission to address this bench individually and collectively as your lordship.
Yes, you have.
Yes.
Much obliged, your lordship. May it please the court, I'm the counsel for the respondent Union of India. My submissions will entail the constitutional validity of IT Rules 2021. If the court is well versed with the facts, the counsel would like to proceed with the issues at hand, your lordship.
Yes.
Much obliged, your lordship. Your lordship, arguments will be raised in three issues in totality. The first issue would be the issue of maintainability. Secondly, the constitutionality of Rule 42 of IT Rules 2021. And lastly, the imposition of criminal liability under the said rules. The first two issues will be dealt by me. The last issue will be dealt by my co-counsel. If with my lordship permission, I'd like to proceed with the first issue at hand. Your lordship.
Yes.
Much obliged, Your Lordship. Your Lordship, issue of maintainability is being challenged in the present instance. That is, it is a settled law when it comes to maintainability as an issue that it can be raised at any stage of proceedings and need not be limited to the preliminary stage. The counsel for the petitioners in their present written submission as well as oral submissions have not captured this position, and therefore it is humbly pleaded to this court that any grounds that will be raised thereunder shall be considered as uncontested. That being said, Your Lordship, I'll be raising this particular issue on a threefold submission. Firstly, that there is no violation of fundamental rights and there is clear absence of locus standi. Secondly, that the rule of exhaustion of alternative remedy has not been extinguished. And finally, that the nature of the case involving technicality does not allow us to do so.
You please first of all address whether this legislation can be at the instance of the Secretary of the Government, that too by way of a rule.
Indeed, Your Lordship. My second issue thoroughly captures that particular aspect. I'll start with that second issue, Your Lordship.
Yes.
Much obliged, Your Lordship. Your Lordship, just to explain background for my second issue, that is the constitutionality of Rule 42. It basically says that, let's say, if there is a person X and he has a text or a video or a image that he forwards to certain 5 people. It could involve fake news. It could involve child pornography. It could involve rape or gang rape imagery. And he forwards this to 5 people. They in turn forward to another 5 people. This WhatsApp forward becomes viral. And then through Rule 42, what we are empowered to do is identify this particular originator. This is entirety of the Rule 42 that requires from the intermediary to do. That is just the registration ID of the particular person who is registered with their institution. We need that information. We will give you the message. We'll give you the viral video, whatever you may need, up with appropriate judicial order or a competent authority order. You just give us the information. The respondent in reply has stated that they would use grounds like there is lack of legislative competence, there is manifest arbitrariness, there is a violation of fundamental right, but would not comply with the provision by stating that it requires breaking of end-to-end encryption. Your Lordship, this is not even an issue, because end-to-end encryption, what councils are stating is it's a platform where, let's say, I am a user, I send a message, and the person is X is a Y is a receiver. Only these two people will know the content of this message. This is the entire platform of end-to-end encryption. The petitioner submit that they, for in order to comply with the rule 42, they have to break this end-to-end encryption, which is not the intent of rule 42, is what we are submitting. If you look at the bare reading of rule 42, Your Lordship, nowhere does it mention the term break end-to-end encryption. All does it say is you give us the identify the originator of information. It is up to you how you deploy this particular technology base. That is the background, Your Lordship. And to address this particular ground, the test of rulemaking is challenged, and the state of Tamil Nadu versus P. Krishnamurthy has laid down the test of when can a subordinate legislation be questioned. For this, there are certain grounds. Firstly, if the particular legislation suffers from legislative competence, lacks legislative competence. Secondly, it exceeds the authority under the parent statute. Thirdly, suffers from manifest arbitrariness. And lastly, that it violates any of the fundamental rights. Each of these grounds are being categorically discarded in my present submission. At first two grounds, Your Lordship, there's clear rationale and justification to enact this particular legislation. Right from the outset of Prajwala case in 2018 by this honorable court in the suo motu petition, it essentially directed us to frame guidelines to curb this tendency of fake news that is rapidly spreading. That time, there was a lot of hubbub that was created for a mob lynching case wherein a particular message incited a communal violence. Secondly, there was a calling of motion by Rajya Sabha in the year 2018 in that year, stating that we can have an elaborate discussion as to what could be the possible recourse to hold these social media companies accountable for their role to play in the curbing of fake news. Then subsequently, Rajya Sabha committee in 2020 February 1st gave a report in which they recommended that first originator of information may be identified, for which we request you to permit breaking of end-to-end encryption. This is what we recommended in that particular committee, and we've noted that down and we kept it with ourselves. In 2018, Your Lordship, we started amending the draft IT rules 2011, wherein we invited over 187 public consultations, wherein key stakeholders involving this legislation, this could include digital media, this could include the social media companies as well, were invited to give their concerns, and a public opinion was raised. And therefore, after addressing all these, the 2021 legislation was enacted in February of 2020. The originator of information rule being coming into force in July 2021. At this juncture, Your Lordship, I can clearly establish that there was a rationale for enacting this particular legislation. And also considering the fact that when we talk about public disorder, that is the message, incitement of a message, it is amply clear from examples like Manipur case, where a simple tweet led to a vociferous civil war type situation between two communities in the state, which led to imposition of certain like blanket ban of the internet. It could have been maybe provided by just identifying that particular image. There was also a case in DJ Halli versus DJ Halli, where in the state of Bangalore, where just a mere a tweet by a singular person led to a vociferous communal violence in the particular city, which lasted the whole night. All this is what we are telling telling the social media institutions to avoid and allow us to do our job and aid the law enforcement agencies. But this is something that they cannot comply with. Questioning the aspect of rule making power to challenge the legislative competence, Your Lordship. Firstly, the IT rules is being governed by is governed by Part 2 and Part 3. That is, your Part 2 is governed by the Ministry of Information Technology. Part 3 is by Ministry of Information Broadcasting. As per the with your Lordship's permission, my counsel would share the screen for your Lordship's convenience, if that is okay.
Yes.
Much obliged, Your Lordship. So the new allocation rules of Government of India, India 1961 allotted the Ministry of Information Broadcasting, the IT administration, the cyber laws and IT related laws under its ambit. And 1 second, Your Lordship, I'll wait for my counsel to share that. As you can see in entry number 5, Your Lordship, the matters relating to cyber laws, Administration of Information Technology Act, and other IT related laws is being governed by the Ministry of Information Technology, and matters relating to the digital media is being governed by Ministry of Information Broadcasting. So there is the need of demarcation or overlapping of ministries here, and there is no question of legislative competence. And insofar as the enactment, the rule making power, that is Section 87, Clause Z and ZG. My
Yes.
co-counsel will be sharing that appropriate thing. The clause ZG prescribes procedures and safeguards to enact to carry out blocking order for the public, and ZG prescribes guidelines that may be followed by the intermediaries as given by this as may be prescribed. So, Your Lordship, this enactment is particularly within that scope of that clause Z and ZG, because it's a guideline that is presently prescribing. And Your Lordship, there is no question of us having exceeding the scope of the parent statute, because the parent statute allows us to presently do this particular aspect. So, in essence, Your Lordship, that aspect is being rectified. Now, addressing concern of manifest arbitrariness as well as the violation of fundamental rights. Your Lordship, like my fellow petitioners were saying, the violation of fundamental rights arises. The violation of manifest arbitrariness, that is Article 14, arises in the case where there is an action that is arbitrary, or it is without any adequate determining principles. In the present case, there is severe checks and balances right from the initiation of identification of the person. Firstly, there is a requirement of a legislative order or a competent authorities order, without which we cannot identify this person. Secondly, if there is a least intrusive method, we have to choose that. Thirdly, Your Lordship, we are not supposed to ask the content of the messages. We will give you the content of the messages. You just disclose the registration details. Fourthly, Your Lordship, it can only be issued under the grounds of national sovereignty, security, child pornography, or protection of women. So, under no context can this action be said arbitrary, because it has severe checks and balances and with it complete adequate determining principles. And violation and concerning the violation of fundamental rights, which my co-counsel was petitioner was addressing.
Counsel, please wait.
Indeed, Your Lordship.
Before going ahead, can you tell me what is the difference between a statutory rule and a guideline?
Indeed, Your Lordship. The statutory rule is when there is a proper procedure that is followed while establishing the law. Guidelines are for the temporary measure that may be enacted.
Not temporary, rather. Rules are enforceable. You are bound by the rules. Guidelines are rather advisory in nature. Now, 87ZG gives you power to make guidelines to be observed. Now, you have made these guidelines in a rules. You have incorporated in a rules. Enforceable rules. How will you justify? See, providing guideline is something, and making statutory rule is a totally different thing.
Indeed, Your Lordship.
So when the rules, when the rule making power say, even though it's a rule making power 87, says that you can make guidelines, then how can you put it in a mandatory statutory nature like this 2021? Rules.
Absolutely, Your Lordship. I could understand the concern of the Lordship, but however, there is not just the guidelines that can be prescribed, Your Lordship, but also the safeguards and the procedure for blocking of access can be also be prescribed under clause Z, which is takes the power from
Z
clause
is not under
69.
challenge now. Z is not under challenge. We are not concerned with the
Indeed, Your Lordship.
87Z. We are concerned with the ZH or ZG.
Indeed,
That's
Your
why
Lordship.
when the statute say you can make guidelines, taking into consideration all things, you are incorporating these guidelines in a statutory rule, which is enforceable.
Indeed, Your Lordship. Your Lordship, just to address this aspect, it is just guidelines related to intermediaries. It may be in the form of due diligence that may be prescribed, and what we are incorporating is the due diligence within the ambit of the IT rules, which has already been upheld as constitutionally valid in the case of Shreya Singhal versus Union of India. What it is a mere supersession. It is an amendment. That is, there is no way we are creating a new law of recognizing such a requirement. So it is clearly within the tenets of the ZG clause for the present case.
Dear
It's
participant,
Your
please listen for a
Indeed, Your
moment.
Lordship.
See,
Indeed, Your Lordship.
I think you may agree with me to the legal point ever settled that a rule shall not be repugnant to the spirit of the act. Correct?
Your Lordship,
A
your
rule,
voice was breaking out.
a rule shall not be in contravention with the principal act. Will you
Indeed,
agree
Your
with me? Then you please
Absolutely.
read 79. 79 is a special provision which deals with exemption from liability of intermediary in certain cases. And say, notwithstanding anything contained in law for the time being in force, but subject to the provisions of subsection 2(3), intermediary shall not be liable for any third-party information, data, or communication link made available or hosted by him. Yes, we agree. Section 79, 70, 87 gives powers to the government to make rules, and as far as the case in hand is concerned, the same is ZG, as rightly pointed out my senior brother judge. You see, as rightly put, you see, ZG is regarding guidelines formation alone. I may agree the fact that sometimes maybe the guidelines may also have the same have force of law because of the judgment, etc. You read. But the question is this: when the 79 specifically protects intermediaries, how can a rule can be framed to make them criminally liable for the same without amending Section 79? That is the vital question.
Absolutely, Your Lordship. I can understand that concern. Addressing that situation, if I could direct Your Lordship's attention to the Rule 7 of the IT Rules 2021, which talks about non-observance of rules. What is the consequence of that? It clearly stipulates that only if an intermediary fails to observe these rules, then Section 79 will not be applicable, and then they will be made criminally liable within the provisions of the
that also in the rules. You see, that also is not in the act. That also is in the rules. The rules itself is outside the scope of your powers. Then what are the provisions of the rules? If it is something protecting or negating Section 79, that also equally not enforceable. You must point out something in the IT Act itself so that 79 protection is taken away, or else you should have amended 79, then go for these rules. For which, what is your answer?
Yeah, indeed, Your Lordship. I can address that as that aspect. The Section 79 stipulates that the condition may be applicable in three situations. That is, if the intermediary is not is hosting a web platform for people to come together, or secondly, it does not alter the information that is being transmitted in any way, and lastly, that the due diligence that has been prescribed by the government has been followed. Your Lordship, the rules that are being stipulated is the due diligence that is being prescribed, and the non-compliance with this is what what leads to the criminal liability imposition. It is very much in consonance within the Section 79. If intermediaries, that due diligence are not just limited to Rule 4.2, but as well as Rule 3, where you may have to appoint chief compliance officer, where you may have to create a local server. All these are mandatory due diligence that they have to follow, and even if requisite of failing of one of these due diligence, you may be held to be your safety net, that is the liability exemption, will not be applicable, and we will take you with the imprisonment or the penalties that are prescribed within the IT Act. It satisfies Your Lordship's question.
See, you are not answering correctly, please. 79 is a clear bar. That is a statutory, sorry, that is an act passed by the parliament. In the set Act passed by the Parliament, there is a provision which enables the government to make rules, and it is well settled that the intent behind passing rules is only to enforce the provisions of the Act, not for the purpose of creating new law, that in particular to make a provision in the principal act as redundant, inoperative, and to make it as null and void. If so, unless and until 79 is not amended, the rules, that is particularly 4.2, how can the test of constitutionality can be said to be passed? How we can pass it?
Your Lordship, retreating back the same position, not just the section 79, but we also have to take into consideration section 69A. What essentially both of these aspect reads in conjoined says that if you do not comply with the due diligence, that is, you first of all, you need to, if you're an intermediary as defined under section 2 clause W of the IT Act, you will be exempted from certain liability. This liability is only contingent upon you satisfying three conditions. That is, you are not initiating the transaction, or you're just providing the communication system, or if you're following all the due diligence as prescribed. If this is not followed, then there is no question of you having the safety net or exemption of liability. Section 69A, on the other hand, talks about monitoring and decryption of certain messages. That is, if the government, in the interest of national security or sovereignty or integrity, feels that there is a requirement of decryption of certain messages or monitoring certain messages, then it may do so by observing certain rules that may be prescribed under section clause 3. So this enactment of IT rules, which is constitutionally upheld in the Shreya Singhal case, is a direct relation with that. And there is no question of over regulation, or there is no question of exceeding the scope of the Parent Act in the present case.
Please read. You please listen. If your argument is accepted, you will have to say that there is a repugnancy in between section 70 and 69A. 79 and 69A. On closely reading 69A, the power is given, as the title shows, power to issue directions for blocking for public access of any information through any computer resources. So section 69, even though given power to the government to block anything, I am not detailing anything, 69A never provides the government to make rules in violation, making 79 redundant. Of course, 69 can be imposed in a particular case dealt therein. Therein, interest of the sovereignty, integrity, defense of India, security, whatever it may be, friendly against anything. But 69A cannot be read in isolation, ignoring and making 79 redundant. 79 is the safeguarding provision insofar as intermediaries are concerned. If so, unless and until 79 continues, is it fair on the part of the government to make a rule which in fact takes away or nullifying 79 itself, unless an amendment by the legislator itself is not being introduced? That is the vital question.
Indeed, Your Lordship. Addressing that particular concern again, the section 79 subclause 3 also mentions when this the provision may not be applicable, which relates to the intermediaries or any person notified by the government who, upon receiving actual knowledge that it could be with judicial order, may be exempted from the liability of the section 79, may not be exempted from the liability under section 79. This is again was elaborately discussed in the case of Shreya Singhal versus Union of India, where from actual knowledge being would mean that you have to actually receive the court order, and only then can you not comply. This is directly in relation with when you do not observe the rules prescribed, or when we give you certain notification, Your Lordship.
Yes, you are on which provision?
Section 79 clause subsection 3, Your Lordship.
3 reads as an exception.
Subsection 3 subclause B. Subclause B talks upon receiving actual knowledge or on being notified by the appropriate government.
Yes, it's agency that by information, data, or company residing. used to commit and it fails to expeditiously remove the source without evidence in any manner. What is the impact of section 79(3)(b) according to you?
As per me, Your Lordship, if at all, if we are notifying the government, the intermediary to disclose a certain information, and they do not disclose us with actual knowledge, if they receive the judicial order, then the exemption that is made applicable in 79 will not apply to them, and they will be made liable, and which is presently the entire rule. That is, if you do not comply with the provision, we will then impose criminal liability. Give you appropriate order with actual knowledge, we'll give it to you. But if you do not comply with it, we'll impose the criminal liability.
Yes, yes. So you may be able to answer my query in a way within the materials available currently, because that is the answer I am in search of. Even though 79(1) imposes an absolute restriction, 79(3) is the exception. There, a particular area has been dealt with, and acting on your argument, my understanding is that the rules, particularly section 4, rule 4(2), is in tune with 79(3). Correct?
Absolutely, Your
Yes.
Lordship.
Yes. You may go on. Yes.
Much obliged, Your Lordship.
Yes.
Now, addressing the final leg of my first issue, that is the violation of fundamental rights. Your Lordship, there is a concern of the petitioners that the present rule violates not just the fundamental right of free speech and expression, but also the privacy. Addressing this juncture, Your Lordship, I would the free speech and expression or right to carry out your occupation is not something that is absolute. It is subject to reasonable restriction, as your lordships have stated, and it comes under this broad umbrella term public order, wherein it includes your security, your sovereignty, integrity, as well as morality and decency. In the present case, your lordship, we have taken instances where when we question about encryption versus national security is taken, then the national security is given precedence. That is, your personal liberty must be equal, balanced with the interest of the national security. And in the case of Manohar Lal versus Union of India, State Ex-Army Men Private Limited versus Union of India, as well as the case of Tehseen Poonawalla versus Union of India, have categorically stated one unison principle. That is, and I say this with the deepest of respect and utmost of humility, Your Lordship. What is a matter of what is in the interest of security is not for the court to decide, and it is best left for the executive. And when it comes to the certain questions of categories where certain information has to be disclosed, the competent authority, being an executive, may be the right method to identify such information, and we will sign copy and give it to the intermediaries to disclose such information. And in regards with the privacy aspect, Your Lordship, the current test satisfied the three-part test set forth in case Putuswamy versus Union of India, wherein it stated that there is requirement of legality, necessity, and proportionality if you're balancing the right of privacy versus invasion of such privacy. So here the legality talks about recognition of a valid law imposing such a requirement. Here we have established that section 87 clause Z and ZG as well as section 69 empowers the government to draft this legislation. The second aspect talks about necessity, wherein we talk about the state's legitimate interest to regulate the trafficking of the child pornography, the CSAM material, the protection of women through gang rape imageries, as well as the fake news. And lastly, the proportionality test, where the least intrusive method may be adopted. We have had several discussions, consultations, legislative discussions as well to ascertain that the least intrusive method may be in regards with identifying the originator of information, curb the fake news. However, we have also given the liberty for these intermediaries such as Postgram to ensure that they can deploy their own technological measure and not break end-to-end encryption in any sense. So therefore, Your Lordship, it is humbly submitted that the aspect of violation of fundamental rights is not even in question in the present case. If that satisfies Your Lordship's queries, I would proceed with my last issue at hand. And
Yes, dear
I would also
participant,
like to...
One question. Let me ask one question.
Indeed, Your Lordship.
I think you agree with the proposition that if the wordings of a provision gives rights to scope of arbitrariness, arbitrary interpretations by the authorities concerned,
Absolutely.
and it is likely,
Indeed, Your Lordship.
it has to be abrogated. I think you agree with it.
Lordship, if there is any scope
Yes.
of ambiguity, then we have to definitely.
Yeah, yes. So just come to the proviso 1 to for rule 4.2. Then the proviso 1, first proviso, gives the circumstances or the contingencies in which this order has to be passed by the authorities concerned. That is, when it is required for prevention, investigation, punishment for very serious offenses. I stress on that. Punishment for very serious offenses. I think you have come to it.
Indeed, Your Lordship.
So when it is required for the prevention, investigation, or punishment of very serious offenses, I emphasize on that. Very serious offenses related to sovereignty and integrity of India, security of the state, friendly relations with foreign state, or public order. Then my question is, how can you define whether this public order is defined in any legislation? Or how can you say that a particular instance is a very serious offense of public order and another instance is not a very serious or a silly offense of public order? How can you distinguish? Will it not give authority? Will it not give power to the authorities concerned to exercise the power arbitrarily, saying that there is a very serious issue of public order, and in another case saying that this is not a very serious issue of public order? Whether public order is defined anywhere? Public order.
To address this particular concern, I'd like to highlight that the
Speaker
entire.
one, you may please note your allotted time is over.
Yeah, please give him 3 minutes more. Please give him 3 minutes.
Okay.
Yes.
Indeed, Your Lordship. To address this particular aspect, the entire requirement of Rule 4.2, that is identifying the originator, depends on one crucial element, Your Lordship, that is the virality. Let's say if you send a message and only if it becomes viral enough to come to our notice, right, then only then can we send out a message under any of these grounds that it could fall under. So the question addressing whether what is the serious offense, it could be in relation with the virality in itself. Without element of virality, we may not be able to prosecute a person. If the person has just forwarded it to 5 persons,
can
and
you
that
just
stops there.
please for the inference, can you just enlighten me whether public order is defined in any legislation?
Your Lordship, as of right now, the council is not aware of any judgments. But however, for the sake of expand, the legislation has deliberately left out the definition of public order as to suitably match the changing circumstances and evolving situations. It might be very different for a certain circumstances, and it might require a very different lens and perspective for a different situation. So therefore, the legislation's intent is deliberately has not defined the term public order in the
So that means it is left to the discretion of the authorities concerned to say that this is a serious offense of affecting public order and this is not a serious.
Indeed, Your Lordship. But however, that is what
Yes.
I stated in my submission, Your Lordship. When it comes to what is in the interest of national security, is not a matter of question of law. It is a question of policy. And it is best left for the executive to decide and not for the court, Your Lordship. And this reliance is placed
Speaker
in the
one,
case of
your
Manohar
allotted
Lal.
time is over.
So please give him
If you're
2 minutes more. 2 minutes more. Please give him 2 minutes more. Yes, you may proceed.
The reliance, indeed, Your Lordship, the reliance is placed in the case of Manohar Lal, where Pegasus spyware was being challenged as where a limited counter affidavit was filed by then Attorney General, as well as in the case of Tehseen Poonawalla, where they upheld this principle as well. The limitation of judicial review when it comes to the matters of national security is very curtailed, and it is something that is a matter of policy that is carried out.
It's not that issue which I have asked you. The question is, when a provision is interpretation of provision is likely to give rise to arbitrariness. That is the issue. That is why I ask you, can you hear me?
Indeed, Your Lordship, I can hear you.
Yes, can you hear me?
Indeed, Your Lordship.
Yes. What I want to know,
that again, Your Lordship. If
Yes.
the aspect does not fall under national security, it will fall under the term of child pornography, which may be dealt by the judicial order, which again the wisdom of the appropriate judge may be applied and subsequently decided. The reason being that public order is a very evolving term, and it cannot be defined to limit its application. That is the rationality behind such an enactment, Your Lordship.
Yes.
If I get a certain for 4 minutes of time to just explain the maintainability
Mr.
as an issue.
Mr. Participant, you
Your
answered
Lordship.
that you never came across a decision of the apex court. You please read the decision Ram Manohar Lohia versus State of Bihar, 1965 Supreme Court, wherein Supreme Court classified and defined what is public order.
Indeed, Your
1965 Supreme. Ram Manohar Lohia versus State of Bihar. Yes. You continue. Yes.
Indeed, Your Lordship. Just 5 minutes of granting time I would like in case of raising the issue of maintainability at your court's discretion.
Please go ahead.
Much
Yes.
obliged, Your Lordship. Your Lordship, issue of maintainability is being challenged on 3 fronts. Firstly, that there is no violation of fundamental rights as established by my second issue, and clear absence of locus standi. To address this particular ambit, Your Lordship, what essentially locus standi means is that we have to explain who is the person who is approaching before the court. That is, you could be either the person whose fundamental right is being violated, or you're representing someone whose fundamental right is being violated. The latter is what we call as representative standing, or commonly known term is public interest litigation. Your Lordship, state of Uttaranchal versus Balwant Singh Rai is the settled law when it comes to maintenance of PIL before the Supreme Court. That is, the genuinity or bona fideness of the petitioner must be established before proceeding with that, and he must be espousing of general interest of public. Here in the present case, the entire cause of action is originating from post-grant due to their non-compliance with the Rule 4.2. Second, they have a complete self-interest involved, and they cannot be held as a public-spirited body or someone who has who's a NGO that is espousing a greater public interest. So presently at this stage, Your Lordship, the locus standi requirement for PIL is not met. And even on the consideration that public interest is something that is to be considered, and we would hear this particular matter, there are 2 impediments coming between this bit for this court. That is the issue of rule of exhaustion of alternative remedy, which simply states that if there is a competent jurisdiction which can hear your matter, it could be either listening to the bias of a statute or violation of fundamental rights. You approach to that court first, then you come to us, and we'll hear your matter if the relief is not granted. This is particularly relevant as this has become a settled law in the case of Siddiqui Kappan's case versus Kannubhai Brahmat versus Union of India, as well as Satish Chandra versus Union of India, wherein the court has categorically stated the High Court is an appropriate jurisdiction for you to approach first and then appear before the Supreme Court if the relief is not granted. So therefore, Your Lordship, given that this rule is not satisfied, because there is a pending backlog of cases that takes an immense number of time, I'm not even going to quote you the writ petitions, especially petitions, but just stating the PILs that are filed in the year of 2022. There are staggering number of 103,926 as per the Supreme Court Observer statistics of annual court data compliance. So therefore, Your Lordship, it is humbly submitted to this honorable court that it is this without exhaustion of this rule of alternative remedy, that this particular matter may not be addressed, and this has direct connotation on the summary nature proceeding of the Supreme Court, which only deals with the issue of law and not with the issue of fact. In the present case, a question such as whether compliance with Rule 4.2 actually requires breaking of end-to-end encryption itself is the primary question. Without addressing this, we cannot get into the veracity of what the rule actually entails. So this question requires addressing by an appropriate committee which could decide on this particular matter, and whatever may be the committee's report, we will humbly abide
Judges
by
and
such
participants
report.
may kindly note that the time is over.
It satisfies Your Lordship's queries. I would proceed with my co-counsel will come and argue in the rest of the issues.
Yes.
It was an honor to argue before this bench, Your Lordship.
And Speaker 2, may please note you have 10 minutes remaining and you may begin.
Much obliged. Greetings to the bench. I'm the co-counsel for the respondent, and I seek the permission of the court to begin my submission.
Yes.
Your Lordship, I will be restricting my submission to the third issue at hand, which is whether imposition of criminal liability for non-compliance is unconstitutional. Your Lordship, before I get into that, Let me just give a brief introduction of where criminal liability finds mention in the IT rules. The Lordship, as my co-counsel has already put forth, that IT rules is divided into three parts, and the matter at hand requires the reading of only part 2 of the IT rules, which prescribes the due diligence that all intermediaries will have to follow. The last rule that is given in part 2, it talks about what happens if the said intermediaries do not comply with the due diligence. That is, what happens if for the non-observance of the rules. In such cases, then section 79 will not be applicable to them. Now, that will bring me to my first ground, which is that the actions of the petitioner postgram clearly warrants for circumvention of the safe harbor principle established in section 79. Your Lordship, my co-counsel has already put forth the three conditions that that the petitioner will have to fulfill in order to be not liable for any for any liability for the data that is posted by them. And this data is usually posted by third party, which is the users of these particular platforms. Now, your Lordship, subsection 2 of section 79 puts forth three conditions that all intermediaries will have to fulfill, which is that the intermediaries restrict to just providing a platform for such communication to take place. Secondly, they do not take part in how such communication is regulated across the platform. And thirdly, they adhere to all the due diligence that is put forth by the appropriate government. Your Lordship, the willful and deliberate non-compliance of Postgram in this particular matter clearly amounts to not meeting the third condition, which is that they haven't followed to the due diligence that is prescribed by the government. In this particular case, they're challenging Rule 4.2 of the IT rules. That was my first submission. And second submission is that in nowhere does the delegated legislation exceed the power of the parent statute. Which that what the council is trying to state, that there is consistency in with the delegated legislation. The Lordship, Rule 7 clearly states that safe harbor principle will not be applicable, and the relevant provisions of the IT Act and any other laws that is prevalent in India. These laws may be the IPC or anything that the court wishes to address. So those particular laws will be applicable. Now, your Lordship, now how exactly criminal liability finds mentioned in the parent statute? I would like to read section 69 of the parent statute of the IT Act. And through this particular 69, it empowers the government to provide for orders to decrypt certain sensitive information, usually information that is against the crimes of the nation or involves or can cause havoc to public order. Now, failure of these intermediaries to not comply with such order will result in an imprisonment and shall also be liable to a fine. The reading of the very next section, that's section 69, which empowers the government to issue blocking orders of certain sensitive nation, and this empowers the government to prescribe blocking orders, and failure of the intermediary to not comply with the said blocking order will again put forth a period of imprisonment on the intermediary and shall also be liable to a fine. So what the council is trying to reiterate is that there is criminal liability that is mentioned in the parent statute, and the IT rules. All it does is it reverts the power of attributing criminal liability back to the parent statute. It nowhere does not exceed the parent statute. It is not ultra virus. So those are my first two grounds, and it addressed the question as why criminal liability is necessary for non-compliance of the said rules. If your Lordship has no question, I would like to proceed with the following two grounds.
Yes, you proceed.
Dear participant, I have a question.
Yes.
Indeed, your Lordship.
That question comes from the question already asked by my friend, Honorable Justice Girish. You can't agree with us on the point that the rules lack some sort of clarity, particularly when Section 4.2 will come into play only when the government, the agency requires purpose of prevention, detention, investigation, prosecution, or punishment of an offense related to the sovereignty. Then either in the IT Act or in the rules, an offense related, a serious offense related to the sovereignty of India should have been defined. What is your opinion? Should have been defined. Otherwise, there may be the same is left to the discretion of the investigating officer of the crime to decide upon, which may be arbitrary according to the whims and fancies of the investigating officer concerned. Mr. A thinks this a particular act, say for example, A is a serious offense affecting. At the same time, another investigating officer may say, no. In my view, A is not like that B. Then should have been defined. Do you agree with it?
Your Lordship, my answer will remain the same as that of the council, which is that that such particular important questions should be left to should be best left for the policymakers of a country to decide. This is not something that that question of law can answer, because such which is why the makers of the IT Act deliberately chose to leave out certain definitions. Due diligence is one example. It does not find mention, it is not defined in the IT Act. However, in 2021, in 2011, the appropriate ministry, which is the Ministry of IT and Electronics, they had come forth with the due diligence that have to be followed by the social media intermediaries. In 2021, what was further elaborated was a distinction of the significant social media intermediaries and the social media intermediaries. So, such my answer remains the same, that that such question is best left to the Parliament and the executive to decide.
Definitely, you being a participant in a moot court can only answer this much. That alone is expected. Okay. Yes. You can continue. Yes.
Okay. So, Your Lordship, my first two grounds answer the question as why it is necessary to impute criminal liability. The following my following two grounds will answer the question as to how exactly we can impute this particular criminal liability to the company. Your Lordship, now my third submission is that the action of Postgram clearly requires the piercing of the corporate veil. Now, because Postgram is a body corporate that is established in India, and all body corporates will have two distinct legal personality, which is the company itself and the alter ego of the company. And the alter ego is said to be the mind and the will of the particular company. Now, law has evolved from a time wherein wherein companies could not be held guilty for any crime because of the sheer absence of a mind. And because of the absence of mind, mens rea could not be attributed to the particular company. However, the Supreme Court, through a lot of cases, they have enlarged the scope in which this particular corporate veil can be lifted. And right now, the actions of Postgram in deliberately not complying with the rules clearly calls for invoking two of those grounds. The first ground is that the actions of the non-compliance of Postgram is clearly affecting public policy, as put forth by both Your Lordship and my co-counsel, that that there is a lot at stake here. It is the sovereignty of our nation. It is the public order. It is due to the sad presence of gang rape, of revenge porn on the internet. A lot of CSAM material on the internet, and to curb all this and to curb all of these, it is essential to find out who the originator of such information, because only upon doing so can we cut the problem right at the at the foundation. And in willfully not complying with the said order, this clearly amounts to this is clearly against public policy. That is the first ground. And the second ground is that the actions of Postgram is clearly avoiding welfare legislation. Your Lordship, it is set in law that any action taken by a body corporate to willfully avoid welfare laws, that itself can be a ground in which the corporate veil can be lifted. Now, the reliance for this particular statement is placed on workers versus associated industries, Bhavnagar. It was in this case that the Supreme Court stated that no welfare laws can be avoided. And Your Lordship, based on these two grounds, corporate veil can be lifted. Now, what then? What do we do after that? That will be dealt by in my fourth ground, which is that using the principle of attribution, we can impute mens rea to the company. Now, as I began my third submission, I stated that that back in the day, companies could not be held liable because they did not possess because they did not possess a mind. Now, Your Lordship, in the case of Iridium versus Motorola, the Supreme Court so beautifully imputed criminal liability to the company. So what no company can do a wrong on its own accord, because companies are always run by people, and it is on the actions of this particular of the mind and will of the people. So these could be the promoters, these could be the board of directors, the CEOs, the chairman, the directors. It is only on these particular actions that the company will continue to do its day-to-day activities, and they also can break they also can break laws. Now, the Supreme Court, the Honorable Court, in the case of
Speaker 2 may please note, your allotted time is over.
Your Lordship, could I request for just 2
Go
minutes
ahead,
for my last submission?
finish your
Much obliged, Your Lordship. So, Your Lordship, what the Supreme Court did was they imputed the criminal mind because of the mens rea and actus reus of the mind and the will of the company. They attributed that to the company itself. Now, using this particular principle, what I request the honorable court to do is to also find a postgram limited and for any future intermediaries which are not complying with the due diligence. Lordship, those were my four issues. If your Lordship has any questions, I'm more than happy to answer them. Lordship, am I audible?
Yes, you are audible. Any question, Girish?
Yes,
Your Lordship.
I am again on the point of arbitrariness of that provision, because another clause which I find in that provision is that offenses related to sexually explicit material. What is sexually explicit material? It is likely to be interpreted by different persons in different ways. Some person may say that that controversial book, Lady Chatterley's Lover, that is sexually containing sexually explicit material, obscene material, etc. Some person may say that no, it's not at all a sexually explicit material, but it has to be appreciated on a different perspective. Likewise, some may say that even in the book of Chetan Bhagat, half girlfriend, 400 days, etc. Some may say that there is obscenity in it. Then for some other, no, it has to be understood on a wider perspective, some others say. So again, you are leaving it to the discretion of the enforcing agencies. These arbitrariness, how can it be sustained? That is my question.
Your Lordship, in order to curb the presence of sexually explicit material on these platforms, the government has already dealt with that in the due diligence by appointing a grievance officer. Now, as the Lordship has so
that is a grievance officer. One grievance officer may be of a particular attitude with regard to this, and another may be not, maybe having a different opinion. That is because it is giving rise to ambiguity. That is the difficulty. This term.
Your Lordship, in the cases of, as it put for Chetan Bhagat book or any other book, for such material to be confirmed as yes, this is sexually material, that is up to the judiciary to decide that. Your Lordship, if someone finds offense with such particular thing, they'll have to file a complaint, and it will again come to the judiciary, and they will have to deal with whether this material is sexually explicit or not. The council.
That is true. It is left to the judiciary to ultimately decide it. That is true. But at the same time, it can be used as what you say. These authorities can use it as a measure of exploitation of those persons which they dislike. That is a difficulty.
Your Lordship, with respect to that, again, it's the law enforcement agencies which will look into that. It's a law agency which look into certain viral messages, that is messages that have attained virality on these platforms. And if such the IT rules rule 3 specifically looks into that, as in if there is any private part of an individual which is present on the thing, or if there's any sexual innuendo that is being made use of in order to get virality.
So sorry to interrupt. Your time is over.
Yes, let him complete. Let him complete.
Complete. And I have one question also. Yes.
Okay.
Yes. So, Your Lordship, with reference to such things, it is initially the grievance officer that appointed by the intermediaries to look into whether this particular thing, this particular content needs to be removed or not. And even after removing, the person who has posted such content, he can choose to apply to the appellate grievance officer and he can argue his case as to why his particular content that he posted and got viral is not sexual in nature. And again, Your Lordship, if it is up to the judiciary to decide on whether a particular content is sexual in nature or not.
Yes. I have two questions. The first question is, which is the penal provision introduced by the rules, and if by making a rules under the power of delegated legislation, a punishment can be imposed? That is the first question. Second question, reading the second question in a way answering the first question, but leave it. Section 7 says, when an intermediary fails to observe the rules, provisions of subsection 179 shall not be applicable to such intermediary, and the intermediary shall be liable for punishment under any law for the time being in force, including the provisions of the Act and the Indian Penal Code. So, as per section 7, even the the offense not specifically defined, punishment not specifically defined, and 7 says only one thing, that the protection given under section 17 and 1 in the case of intermediaries shall not be available, and they must be prosecuted for the offenses generally. Then the first question you must answer whether by making a rule a punishment can be imposed. That is the first question. Second question, how this vacuum in section 7 to be addressed?
Your Lordship, so the answer to both the questions could be answered by the due diligence that is prescribed by the government. So section 79, it states, section 79 subsection 2 clause 3 states that all due diligence prescribed by the government will have to be complied by the intermediaries. Now, clearly, the action of postgram do not meet that particular thing. And again, your Lordship, you rightly put forth that the punishment also it goes back to the parent statute, which is in case of blocking order, section 69. Now, failure of any intermediary to not comply with the blocking order will result in an imprisonment, and the intermediary shall also be liable to a fine, whatever the court may decide. So it all comes down to the due diligence that is prescribed, and my co-counsel also put forth that all due diligence it's been taken, it's been put into forth after invoking the powers put forth to the Métis in section 87 clauses Z and ZG. Along with that, it's also the prescription that section 69A gives to the Ministry of IT and Technology.
Then you please clarify. This is the crux of the question. The two questions, if clubbed together, the question is only this: whether the punishment comes from the Act or from the rules.
Your Lordship, the punishment comes from the Act itself, because nowhere does in the rules is any punishment mentioned, which is why in my second submission,
in fact,
I stated that
this is the crux of the issue. But both of you, in fact, not pointed out that. You see, here, as per Rule 7, what is intended is operation of the Act when there is violation of as described in 79(2) and 3. 79(2) and 3 applies, 79(1) will go. If so, because of lifting of 79(1) by operation of 79(2) and 3, the intermediary is also subject to punishment and penalties as per the Act itself. The rule says only that should have been the mode in which you should have presented the case entirely. That is my opinion. Yes.
Your Lordship, I had began my second submission with that particular statement.
Judges and participants, please note, due to time constraints, can we move on to the rebuttals and surrebuttal session?
Yes,
Your Lordship, I request just 1 minute to answer your question.
Please give 1 minute, 1 minute, and then we can go to the next section. Yes.
Indeed, Your Lordship. So nowhere in the IT rules 2021 is the punishment prescribed at all. Rule 7 clearly states that the relevant provisions of the IT Act will be applicable. And in the examples also, I cited section 69 in the decryption order and section 69A for non-complying with the blocking order. And the punishment in both the cases is Your Lordship.
Participant, what I said is correct. So we can go to the next section. Okay.
Your Lordship, I request the permission of the court to recite the prayer.
Yes.
Therefore, in light of the issues raised, arguments advanced, and authority cited, the council requests the Honorable Court to please dismiss the writ petition filed by the petitioner and to uphold the constitutional validity of Rule 42 and Rule 7 of the IT rules, and any other relief that the Honorable Court may be pleased to grant in the interest of justice, equity, good conscience, all of which is respectfully submitted. It was an honor arguing this before this bench. Thank you so much for your Lordship.
Yes.
Now the petitioner side may start the rebuttal session.
Yes.
With the permission of the bench, I'll start with the rebuttals. Much obliged, Your Lordship. Firstly, the respondents raised the issue of maintainability. We would like to contend that fundamental rights are proactive in nature and the citizens will not wait for their fundamental rights to be violated when it is very obvious that the application of such rule will violate these rights. Supreme Court admitted our petition and posted it for the final hearing while exercising its own discretion and wisdom of a constitutional court. The question before the Supreme Court is not only on constitutional validity of the act, which is on constitutional validity of the act, which can be heard with the aptness of the jurisdiction under Article 32. Furthermore, in the case of Indian Oil Officers Association versus Indian Oil Corporation, the court observed that there may be a cause of action which is common to a body corporate as well as to its shareholders, or a cause of action that affects both of them. Often these rights are coextensive, and in those circumstances, the body corporate or a registered trade union or its members can maintain a writ petition. Secondly, Your Lordship, the respondent argued that the ministry invited comments on IT rules 2021 and they were made after due deliberation, but Your Lordships, the amendments were seen by many as to overstep the aforesaid intention, sparking concerns of violating free speech and privacy rights of individuals. A total of 171 comments were received by the ministry, and all of the comments were published for counter comments. They invited the comments and did not even keep them in consideration while drafting such rule. Thirdly, Your Lordships, they failed to give any justification for imposing a criminal liability on us, as pointed out by Your Lordship also. Section 79 3B of IT Act only talks about blocking public access to such material, and which is being referred to as due diligence, to be followed by the intermediary. And intermediary have already agreed to do so and have further appointed grievance officer to do the same. The parent statute absolutely nowhere mentions any regard of criminal liability on the intermediary whatsoever. Fourthly, Your Lordship, as per petitioners, we don't have any problem to comply with the restrictions, but the restrictions imposed should be reasonable in nature. As laid down, it is causing chilling effect on the speech, as it was laid down in the case of Shreya Singhal, where Section 66A was made unconstitutional on the same ground as in this case. Such rules would be disproportionate, particularly in light of Honorable Supreme Court's warning against invading a law-abiding person's privacy to investigate another's misconduct, as fundamental rights cannot be sacrificed on the anvil of fervid desire to find instantaneous solutions. Therefore, imposing such rule is not reasonable and is not proportional. Lastly, Your Lordships, they have not even addressed the concern of classification that has been made between SMI and SSMI, as raised by the petitioners. The contention still remains that the classification is discriminatory in nature, as it is arbitrary, artificial, and invasive, and leaves a large scope for abuse of power, and there are no checks and balances for the same.
Do you have
Thereby,
a case that section 79(1) is independent and it has no restrictions as per 2 and 3?
If Your Lordship could repeat the question, please.
79(1) is the protection, in fact, given to intermediaries, but such protection is subject to what has been provided in subsections 2 and 3. When a case comes under the category of subsections 2 and 3, if a person, an intermediary, can get protection under section 79(1), ignoring 2 and 3.
Your Lordships, we do not currently have such case in hand.
You see, when the statute says, firstly, a protection, secondly, subsection deals with certain other provisions and some provisos, a protection shall be subject to the restrictions coming under the subsections and provisos. So the protection under section 79(1) is not at all absolute. It is subject to restrictions coming under the sections, and therefore we can say as a law that an absolute bar in interfering with the intermediaries when the situation is one dealt under section 79, 2 and 3. Okay. Yes.
With Your Lordship's permission, may I begin with the rebuttals?
The petition
Yes.
side may please note. Your allotted time is over.
Yes.
Yes.
Which oblige Your Lordship.
Respondents, you have 3 minutes for
rebut-
rebuttals. Please note.
Much obliged. Addressing first rebuttal that have been raised by the petitioners, the first one, they talk about the fundamental rights being proactive, and this is something that needs to be limited to the preliminary stage, and that is what we have addressed consistently, Your Lordship. An issue of maintainability, even after being admitted, it's not a bar to hear that particular issue on the reliance that is placed in the case of peerless win versus the referee, as well as the case of this Kerala High Court judgment, wherein they have stated in Union Bank of India versus Casey Joes, where they've stated that a final hearing may also be appropriate to take the matter of maintainability with the principle in mind, that is right to right to fair hearing must not be violated of all the parties. Secondly, they've told that there is a common action that has originated. Your Lordship, this is what we've stated. If there is a common action that has originated in terms of like their FRs are being violated, there is three impediments that have stopped. That is the violation of there is no being of violation of fundamental rights or presence of locus standi. There is exhaustion of alternative remedy, as well as the nature of case involving technicalities. All these are impediments that acts before them. Insofar as the concern of comments is given, Your Lordship, we have taken into consideration all these 167 public consultations, and we have also taken into consideration the recommendation given by the ad hoc committee report, which was established in the 2020, which is well after the public consultation that was done. So this enactment is on the basis of the recommendation of that ad hoc committee of Rajya Sabha. And addressing the fourth issue that they have stated is that, Your Lordship, they state that they have the imposition of criminal liability is completely invalid because they have appointed grievance officer amongst other things. Then it is beyond moot proposition whether they have actually appointed grievance officer. It is something that we are unsure of from where they are taking this particular source. Secondly, Shreya Singhal case is what the petitioner was also challenging, in which we have addressed that section 66 was while it was held to be unconstitutional, entire IT rules as well as the rest of the IT Act was upheld as constitutional, and stated that it does not amount to chilling effect. So again, that is being vitiated on the present ground. And lastly, Your Lordship, they have talked about manifest arbitrariness, stating that there is no reasonable classification and thereby violating 14. Your Lordship, Rule 6 of the IT Act clearly stipulates that significant social media intermediary may be described anyone who is above 50 lakh user base threshold, and anyone who's the significant social media intermediaries, if they impose material harm as per the section Rule 6 subclause 2, state that if they pose material harm to the society, then they may be also categorized as significant social media intermediary. So there's clear rationality and classification between who can we actually send out this blocking order to. So and the council submission in their entire written submission was that they can switch over from one side, that is SSMIs to SMIs, is completely erroneous, because if they pose material harm, Your Lordship, then we will make sure that we'll send a legislative competence order, and then we'll make sure that they comply with identification of originator. That rebuts all their rebuttals, Your Lordship. Thank you for this opportunity.
With that, session 1, chamber 1 has come to an end. We are most grateful to all the judges present here who have gracefully accepted our invitation to evaluate the final session of our 32nd National Moot Court Competition 2023. It was a great honor to have you all on the panel. And we are also thankful to both the participating teams present here who have put up a valiant fight of words and wit before us.
Now, with the judges' kind permission, may we conclude the session. Participants, please leave the session. Judges may kindly note.
Yes.
Judges may kindly note a representative from the college will be contacting you for the score sheet. Thank you, judges.
All right.
Thank you, Your Lordship.
Thank you.
Thank you.
Thank you so much.
Participants may please leave the session.
Shall we also leave?
Yes, sir.